Good morning, Jack.
Good morning, Bob.
So today, let's talk about President Trump's rage at the Federalist Society. Just a few days ago, he unleashed quite an attack on the Federalist Society, talked about how disappointed it was. He referred to a leading figure in the Federalist Society's history and recent operations, Leonard Leo, as a sleazebag, someone who probably hated America. He felt very let down by the judicial appointments that the Federalist Society had supported. And it seems to me that we ought to talk about that today as a really significant development inside the conservative movement as it affects both thinking about the judiciary and judicial appointments. So why don't you kick us off?
Sure. So first of all, this is not new, actually. It's been building since his first term. The president was very frustrated in his first term by lawyers inside the administration who were telling him he couldn't do certain things. He was extremely disappointed when the federal judiciary, including many judges he appointed in the Supreme Court, where he appointed three justices, didn't go along with his election claims for the 2020 election. And, there have been stories since 2020 of Trump and the Federal Society splitting and Trump being disappointed in his first term judges. The only other thing I'll say to kick us off is, the latest rant came in response to the decision by the Court of International Trade, which had three judges, one of whom Trump appointed, and it almost certainly wasn't a Federal Society suggested appointment. It's been reported that the person was suggested by Robert Lighthizer, his trade advisor. So it was a strange context for the president to go off against the Federal Society, but that's not unusual.
So this escalation, even if the frustration has been building, this sort of escalation, at least rhetorical escalation, you think directly ties into his frustration over the tariff rulings.
Well, that was the context in which as I think it was the context in which he made his latest statements. But there have been news stories going back last year and frankly even to 2020 about the growing rift between Leonard Leo and the president, between the Federal Society and the president. There's a rift about whether originalism, which is the kind of uh, the judicial interpretive approach of the conservative legal movement for the last few decades, really going back to the founding of the Federal Society in the 80s. Whether that was the appropriate approach. There have been a lot of conservatives disappointed in some of the outcomes of originalism or supposed originalist thinking. So this again has been growing a lot. It's not the first time the president, I think, has criticized the traditional conservative legal movement, and a lot of his supporters, people like Mike Davis, have been extremely critical of the conservative federal judiciary. And Russ Vogt and Mark Paoletta, who was the OMB head and the OMB general counsel, were very critical of the Federal Society going back to 2020. So it's not a new development. It's been kind of a brewing part of MAGA 2.0.
Let's talk for a second about what it is that Trump wants and that the people who are complaining, like Mike Davis, wants. I assume at some point, of course, they're unhappy with rulings that go against the preferences of the administration. But is there a different vision of the judiciary beyond simply supporting Donald Trump and whatever he wants to do that they're looking for?
So there's a genuine debate in the legal academy, within the conservative movement in the legal academy, about whether originalism is the right approach, about whether this is associated with my colleague Adrian Vermeule, about whether originalism is the wrong approach. And of course, originalism has been attacked from all sides. But within the conservative movement, there's a genuine debate between originalists and people like Vermeule, who's a common good constitutionalist, who argues for a more substantive conservative vision of the Constitution. So that's it in the academic context. In the Trump administration, it's pretty clear to me that the president wants lawyers in the judiciary who are like the lawyers he has selected for the Justice Department and the White House, and basically lawyers in the executive branch. He wants lawyers who approve his program. And that has been the criterion, not any interpretive principle, the criterion on which the president and his associates have criticized the judiciary as being having insufficient fortitude to basically go along with what the president wants. So I think I don't think this is subtle. The president wants in the judiciary what he's accomplished within the executive branch.
So maybe only on a rhetorical, not a theoretical level. I mean, I'm interested in your views on some of what Mike Davis has said. Mike Davis, whom you mentioned earlier, is the head of what I think is called the Article 3 Project. He's a former counsel to Senator Grassley on judicial nominations. And he has expressed his anger toward the courts and wants to support President Trump and the objective we've just identified. And one of the statements that he makes, and you can find it on the website of the Article 3 Project, is that the courts have been weaponized. There's just a broader corruption of the judiciary that needs to be addressed. And that, in his experience, the opposition, in particular Democrats, are Marxists who are evil. They're evil and they weaponize the judiciary and they believe in censorship. Is that just sort of rhetorical overlay on frustration with Trump not getting what he wants? Or is there some political other notion behind that? Is it more than a rallying cry? What is that?
I don't know what that is. I wouldn't know how to characterize it. I don't think it's an accurate description of the federal judiciary, certainly. Look, conservatives traditionally have had a very different attitude towards legal interpretation, legal process, the role of courts than progressives in this country. I mean, this is an old debate, and it's a debate that's been going on in my adult lifetime. What's different about Trump 2.0 criticisms is it's far to the right of the traditional conservative legal movement and its commitment to originalism and textualism. And it's focused on a much more substantive vision in the hands of the Trump administration on outcomes. So I mean, I don't know how to characterize where that's coming from or what it means, but it's clearly it's grounded in a vision of what the proper outcomes in the federal judiciary are. I don't know what Mike Davis's judicial philosophy is, but he clearly is disappointed that the president has been losing in the lower courts and sometimes in the Supreme Court on the emergency orders docket, although the president has had many wins now on the Supreme Court's emergency docket, and the court still has been, of course, there have been some losses as well. The court has still been a target of the Trump administration and people like Mike Davis's ire.
So beyond attacking the court, and presumably, there's some thought that these sorts of attacks could have some intimidating effect. What is it that this administration could, as a practical matter, substantively do about it? Of course, federal judges have life tenure. What is it that they believe they could do beyond intimidation to sort of change the general course of things here?
Well, they obviously can try to appoint uh, judicial nominees with who have the Trump vision. Emil Bove has been the firebrand in the Justice Department, has been nominated for the Third Circuit. They could also read the report you wrote or that you co-chaired for the Biden Commission, and I've heard conservatives say maybe we should pack the court. Maybe we should increase the number of judges on the Court of Appeals or the Supreme Court. They could get Congress to go along with that. There are a lot of things that, in theory, they could do. I think the main strategy is to try to nominate MAGA-friendly judges. And but I just want to say one more thing about that. There have been lots of reports that the prospect of President Trump's appointing MAGA-friendly judges has led conservatives, older conservative judges on the courts of appeals, not to want to step down. And so that it may be a self-defeating strategy if he doesn't get openings that he can fill.
Well, before we return for a second to Emil Bove, who, as you point out, has been appointed to the president, has nominated him for the Third Circuit. And just to stress, you had said earlier he wants lawyers like he has in the executive branch who are personally loyal to him, many of whom at the senior levels were members of his personal legal team. And Emil Bove is one of them. He was a member of the president's personal legal team. He's currently principal deputy attorney general to the United States. But before we return to that nomination and what it means, Davis has suggested that perhaps it would be necessary, and in his view, it would be lawful, appropriate, for Congress to consider funding cutoffs to the judiciary, although he hasn't said in what way those funding cutoffs would be structured, how they would work. He has suggested investigations might be appropriate. Uh, do you think that's again just bluster, or do you think this could go into a particularly ugly direction
I mean,
if,
sorry, go ahead.
no, I was just going to say, if the Republicans in the Senate or the House were prepared to go along with it?
I mean, it's certainly possible, and that there could be funding cutoffs or contractions. You know, the federal marshal service that protect the justices are ultimately under the supervision in various ways of the attorney general. Um, they could through if they can through legislation cut off funding. I mean, you know, there have been times in the past when Congress has delayed terms of the Supreme Court. That happened in the early 1800s, right before Marbury versus Madison. Congress has a lot of control, especially over the lower federal courts and over the appellate jurisdiction of the Supreme Court. There are any number of things that the political branches, if they got together, can do. I would doubt that the president would be able, with the current Congress, to be able to get majorities to defund the federal courts. Now, there have been, you know, there can be all sorts of jurisdictional things. There's a bill to, I think it's in, there's a provision in the Big Beautiful Bill to narrow nationwide injunctions by requiring, I think, the plaintiff to put up a bond. There are any number of things that Congress and the president can do together to affect, contract, expand the lower courts, expand the Supreme Court, affect the jurisdiction of the Supreme Court. They have any number of legitimate tools to influence the court. And it wouldn't be the first time, as you well know, that the political branches have tried to affect outcomes in the Supreme Court by changing its composition, changing its jurisdiction, and the like. I don't think we're close to that yet. And I haven't heard that coming out of the administration yet. But it's going to be really interesting to see what the Senate does with the Bove nomination. I think that's going to be a real moment to see whether Trump is going to be able to change the composition of the federal judiciary the way he wants, and if not, what else he might do.
Yes, and by the way, just a quick note, because you mentioned the Biden Commission on the Supreme Court of the United States, it didn't recommend court
Yeah, I
expansion.
didn't mean to, correct. I
Right.
should have said that.
Right. It evaluated, however, there was an entire chapter devoted to the debate over, what the proponents call expansion and what the critics call court packing.
Yeah.
But on Bove, just to be clear, a personally loyal member of the president's personal legal team, but also battle tested in the course of this administration, given the role that he played in the dismissal of the prosecution of Eric Adams in New York. I mean, do you want to say something about that? Because these are the sorts of issues that are sure to come up in the course of the debate over this nomination.
I'll just say that in many respects, in terms of enforcing the president's will through the Justice Department, including he took the lead in the firings and other machinations with regard to the Eric Adams prosecution. But he has proven himself, let's just say, as starting with representing Trump and certainly with his actions, representing Trump privately and certainly with his actions in the Justice Department, he has proven himself to be a thoroughly credible Trump loyalist. So it's going to be interesting to see whether during his confirmation hearings, Bove can, what his attitude is going to be. I mean, is he going to embrace the view that Trump loyalists have expressed, that his job is to reach outcomes that will ensure that the president wins? I would doubt that he would be able to say that publicly. So then, but we'll see. I mean, that would maybe be a real MAGA test, but I doubt he'll say that publicly. I expect he'll say what most nominees say, that I'll follow the law, I'll be detached, I'll follow the law wherever it leads. The second question is, can he credibly say that given his record? That'll be the real question.
Yes, and of course, we've seen often enough over the years, nominees say it, nobody quite believes it, but then members of Congress, members of the Senate come out and say, well, I'm really glad I heard that answer and I'm very reassured by it. And that's the end of that. Um, so,
But it's pretty interesting to see. That's what I meant by can he credibly do it? This is someone
yes.
with a track record of complete loyalty to the president and in executing the president's will. And the question is, can a person like that make the leap from Article 2 to Article 3 in a way that exercises the judicial power properly? And we'll see what that means for the Senate and whether he can credibly convince the 50 members of the Senate to vote for him, thereby making the vice president the tie vote, the vote to break the tie.
Yes, and you can imagine a pretty dramatic Senate confirmation hearing in which the Democrats call as witnesses the lawyers who resigned from the Southern District of New York in protest over the direction from Bove and his response to their resistance of the Eric Adams prosecution. So let me just summarize and ask you a summary question, because you were talking about extreme steps or increasingly extreme steps the administration could take to force this change in the judiciary that they're looking for. And you said the Congress has a lot of power, and there's a number of things that they could do. So investigations wouldn't be out of the question, fund cutoffs wouldn't be out of the question, court packing wouldn't be out of the question. And so somebody might ask the question, how realistic is this? And you were addressing the question of, should we really be concerned about it now? Maybe not yet. But when you look at what Trump has done, say, in the university context with Harvard or with the law firms, when you look at the steps he's been prepared to take, is it that fanciful to think that given the escalation in the attack on, say, the Federalist Society and judges who are not compliant, that this could move rapidly in this direction?
Well, again, I mean, I wouldn't take anything off the table when it comes to the president trying to execute his will. And if there's any step available, setting aside norms, if there's any path that's plausibly lawful that allows him, or sometimes not even plausibly lawful, that allows him to gain control over an institution, we'll see that he'll take that step. I just think most of the steps we've been talking about, including the ones you mentioned, and jurisdiction stripping or jurisdiction changing to affect outcomes, those are going to require the consent of the Congress. The president can't do that on his own. The only step that I think the president can plausibly take, and it would be a serious escalation, is to, and I don't know the details about this, but I know that the Marshal Service, in some sense, reports to and is under the influence of at least the Attorney General, and in some respects not, but in some respects so. So I can imagine that being a pressure point where the president can unilaterally exert pressure if he wants to play real hardball. The other steps, besides the threats, and including the threats against judges or the attacks on judges, and the threats not to comply with judgments, that's another escalation move that the president could do. But basically, not complying with judgments, doing something with the Marshal Service, and verbal threats. Also, not and by Marshal Service, I mean minimizing the protection for the judges. That's why that's so important. Those are the steps I think the president can take unilaterally. The other steps require Congress, and I'm not confident that he'll be able to get something like court packing through this Congress.
So just one quick question on steps he could take. The FBI has announced that it is planning to reopen an investigation into the leak of the Supreme Court draft opinion in the Dobbs case. I would think, and this could lead to my last question about the court's response to all of this, but I would think that cannot be a welcome development at the court. This is not an intervention that the court has requested. It hasn't asked for the SBI's support. It closed out that inquiry and conducted it internally for the most part. I think it did get some support again on request from the Secret Service, but I'm not familiar with the details on that. Isn't that an escalation right there? The idea of FBI agents swooping down on the court, seeking to interview witnesses, potentially demanding documents to investigate the leak of a document after the court itself had investigated it and closed out the investigation?
If they did it, it would be an escalation. I mean, think about the Trump administration. They float all sorts of things, and I would say a very small percentage of them ended up happening. Remember, habeas corpus was going to be stripped 2 weeks ago, and we haven't heard about that since. If they actually opened an investigation, and it's not hard to open an investigation, I'm not sure what the predicate would be. I'm not sure what law was violated. There's nothing the court could do about that, but I think the court itself certainly would not cooperate, and I believe it would have, depending again on the predicate of the FBI, I don't think the court would cooperate, and I think it would be on strong grounds not cooperating. But of course, the FBI can investigate former employees and the like if it can establish a predicate purely within Article 2. I don't think there's anything the court can do to stop that. And I guess that would be a threat of sorts to the court as an institution in charge of its own security. But again, its own security is in some sense tied to Article 2. I mean, so it's a kind of dodgy context.
Yes, and the administration is well aware that even the threat of an investigation, much less the first steps, could literally prompt the court to have to hire attorneys, individual justices hire attorneys, former employees hire attorneys. And we've talked before
Yep.
about in postings on our site about the cost to people of the mere threat of or conduct of an investigation at any level. Last question here. Again, as thinking about this as somebody who has been in the administration as a lawyer and thought about the administration's posture before the courts, what helps it move its program legally and what doesn't, how does any of this help it with the Supreme Court of the United States with the major issues that are likely to come, that in fact are coming before it and will continue to come before it?
So there are two theories here, and we've been talking about them since January. One theory is the theory that Russ Vogt circulated and that some in the administration I know hold, is that threatening the courts, threatening not to comply with judicial judgments, will ultimately lead the Supreme Court to rule more favorably than it otherwise would in support of the Trump administration. The opposite theory is, and these are not necessarily incompatible in different cases in different contexts. The opposite theory is that the administration is blowing its credibility before the Supreme Court, and that the court will, across the run of cases, especially when credibility and trustworthiness are at issue, will at the margins rule against the administration because of this. I just think I don't think that the bullying has had a notice. It's hard to tell, but because you don't know what the counterfactual is, the bullying has not had a noticeable impact on the lower court rulings. It's just too early to tell for the Supreme Court. They've really only had 8 or 9 rulings, and they've all been on the emergency orders docket in these kind of interlocutory postures. So I think it's just too early to tell, and that's going to be a big issue for the rest of this year and next year, I think.
Well, then we'll leave it at that. Thanks so much.
Thank you, Bob.